All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in 4 cases this morning. 2 are consolidated. First is 2922, Zive versus Sandberg from Collin County and the 5th Court of Appeals District. Then the consolidated cases, 2977, Texas Department of Public Safety against KT, and 2175, ex parte Ferris, the first from Denton County and the 2nd Court of Appeals District, and the second from Collin County and the 5th Court of Appeals District, and as I said, consolidated for argument. And then the last is 21165, Henry Whataburger Restaurants, petition for writ of mandamus from El Paso County and the 8th Court of Appeals District. The court has allotted 20 minutes for each side in each of the arguments, and we'll take a brief recess between them, finishing them before lunch. The arguments are being webcast live this morning on the court's website and will be available later in the archives. Justice Lehrman and Justice Devine cannot be present this morning, but both expect to participate in the decisions of all the cases. We're ready for argument in 2922.
May it please the court, Mr. Lippy will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning to the Honorable Chief Justice and Associate Justices of the Supreme Court. On behalf of Youval, Zive, we greatly appreciate the opportunity to present our case to the court today. We believe that it presents a unique situation for the court to apply and interpret and clarify the rule that was established in Hughes and then reaffirmed in Apex Towing. We believe that the decision in Gray versus Skelton provides additional guidance to the court. I'm certain that the court is familiar with the issues as they developed below. The key question simply is, was the filing of a petition for certiorari by a co-defendant who was seeking to set aside the foreclosure sale that generated the deficiency that was the basis of Mr. Zive's liability, the calculation of the amount of his liability to the bank in his capacity as a guarantor. Was the filing of that petition for certiorari and its pendency a continuation of the litigation sufficient to continue the Hughes Apex Tolling rule? We believe that it certainly was. We've cited to the court the rules of the U.S. Supreme Court, which we believe make it clear that even though Mr. Zive was not a party in the actual petition for certiorari, that he was necessarily a party to those proceedings in the United States Supreme Court unless and until he opted out, essentially. There's
Mr.
a
Lippy,
procedure.
That rule 12.6, says that he is a party, but he can only benefit from the judgment if he files something. And he would have to file at the time the respondent would file, which he didn't do, is my understanding. So how can he benefit from that rule?
He did not file a response, but we have the leading authority on Supreme Court practice has explained that even if you don't file anything in connection with the petition for certiorari, that you can later file a brief on the merits.
I read that, and I read the rule too, and I didn't see either in the rule or in the treatise where it said that even if you don't file at the cert stage, if cert is granted, then you can still file a response brief on the merits.
The portion that I found said that in a number of cases, one of the losing parties below did not petition for certiorari, but was permitted to file a brief and seek reversal of the judgment on the same grounds.
And I believe that was a brief at the petition stage in those cases.
I did not read the authority in that context, but I do emphasize that the relief that was being sought was to vacate the foreclosure sale. And that would necessarily have benefited our client because his liability was calculated based upon the deficiency. So
is the guarantee agreement in the record, in the summary judgment record that was before the trial court? Mr. Ziv's guarantee agreement that he signed, that's also the basis of the judgment against him, was that in the summary judgment record that was before the trial court?
The guarantee agreement was in the summary judgment record before the trial court on the
I looked
underlying
at it and I
case.
couldn't find it in this case.
In this case, no, I don't believe it was.
Okay. Did the judge take judicial notice of it in this case? Do you know, or was he or she asked to at the trial court level?
No, not judicial notice in the malpractice case at the trial court level. That was not done. What we have done is we have cited to the record in the underlying case, and the underlying case, of course, has the guarantee agreement. It also has the calculations that were generated by the bank, which were based upon the deficiency judgment.
Does it make sense for us to adopt a rule that would require judges and litigants to have to dig through such things and figure out whether or not there are these interlocking situations where a judgment being vacated for somebody who does seek review would or would not affect the person who didn't?
Well, I think the exception in Plastex that this court wrote and the way it's been interpreted by the court subsequently does, respectfully, Your Honor, address that concern. The Plastex, as you know, says that that a judgment reversal as to one party doesn't necessarily benefit others, but the exception is where the cases are so interwoven and interdependent. There were several indemnity cases where one party obtained a reversal, but then did not. But the judgment was reversed as to everybody. Boundary disputes. This party appealed, but his or her boundary impacts the neighbor. So
In Apex, didn't the court say that having a bright, clear rule is far superior to having one in which we have to even make these sorts of assessments, though, for purposes of tolling?
I think in Apex and in every situation where it's possible for the court, given the nature of lawyers, to create bright line rules, I think that's important, yes.
So, I mean, it seems like the two possible rules are if you don't proceed individually, regardless of whether there's any interlocking, interconnection between your case and someone who does, then too bad, you didn't do it, and so the clock starts, or the litigation has to come to a complete stop, regardless, again, of whether or not there was any interlocking, and it might be that you're an adventitious beneficiary of it if it turns out that you wouldn't have gotten relief from the U.S. Supreme Court. But to have a clear rule, we're just going to wait until the litigation is done, and then the clock starts ticking. And how do we choose between those if we want a bright line rule?
Well, the bright line rule is not that easy in these multi-party cases because there are so many complexities in interwoven lawsuits with multiple parties, multiple claims that can impact one, or one can impact the other. This, I think, is a very clear example. Party claiming violation of the automatic stay says the foreclosure sale shouldn't have happened. Party whose guarantee liability is based upon a deficiency wants that foreclosure sale set aside. The key in that is that both of them want the value of the property to be higher, such that it exceeds the amount of the indebtedness, and that was the ultimate goal of the papers that were filed in the trial court opposing the summary judgment in the first place. The plastics rule, I think, is and the exception to it, I think answers the court's concern, because any meaningful interpretation of that case and its progeny would indicate that it's not just any judgment that's reversed that benefits everybody. There does have to be some inquiry into the underlying nature of the case.
But you would concede that no matter what happened, should the co-defendant have prevailed, or the co-plaintiff, the other party have prevailed, it would not affect the judgment against your client. In other words, there might be future claims or divisions of proceeds or something, but the judgment against your client was a final judgment when your client chose not to continue to prosecute the appeal.
Well, the judgment was final as to my client,
Right.
but the petition for cert was seeking in his prayer to set aside and vacate the entire judgment. The nature of his claim was that it would void the foreclosure sale. The calculation of my client's liability was based upon a deficiency. So there would have been a huge vacuum there in the record to support any judgment against my client. And because of the interwoven nature, they're both tied to the foreclosure sale, and they both want the value to have been higher than it ended up being at the foreclosure sale. I think it's that interrelationship that is the key. We're not saying that just any situation, and we're not asking this court to rule that in any situation involving co-defendants that one party can just sit back and they always benefit. Well, what we're saying is that where the claims are so interrelated that one party's success would benefit everybody else.
If we can avoid that kind of satellite litigation where now a district judge is going to have to assess all of that, and to what extent is it interwoven or not, and is it truly going to affect someone's rights, how much is enough? If we can avoid that, we should, right?
Well, I
mean, you might not agree that we can, but if we can come up with a rule that a judge in 30 seconds can say, yes, tolling started, ended at this point, it would be better, wouldn't it, if we could generate a rule that was clear?
I agree that if it were possible to resolve every possible situation with a clear rule, yes, but
why wouldn't either of the two clear rules here do it? I mean, I get it, for your case, it might be problematic, but setting aside this case, I know it's a tough thing to ask an advocate to do. I get it. But if you could, and think about future cases, if we chose either of the bright line rules, everybody would know. And so you would know, okay, if I don't go to the Supreme Court, then my clock starts ticking now. Or if I don't go to the Supreme Court, it doesn't matter because somebody else did, and the clock won't start ticking until they're done. Either one of those, everybody would know, so we would never have a problem in the future. Isn't that right?
I don't, respectfully, I have to disagree. I don't think that we would have the situation where there would never be a problem in the future. Look at Gray versus Skelton. There was a direct appeal from the criminal conviction. He lost. Under the case law, I get convicted of a criminal offense. I say my lawyer was negligent. If I don't get an acquittal, my malpractice case goes down the tubes. In that case, a habeas relief was granted, and that was allowed to extend the tolling.
Isn't that different? Well, isn't that different because the malpractice plaintiff in that case continued to prosecute and eventually obtain the relief that was necessary as a condition of bringing the malpractice claim. And here, your client, forewent future prosecution of his appeal. And so isn't this more like Apex where, we said once you've been dismissed for want of prosecution, tolling stops?
Well, I don't respectfully agree that he forewent taking any action. We were monitoring the case, and we were monitoring what happened, and we would have filed a brief on the merits and sought to go along with Mr. Affletuni in his case. And we would have had that ability to do so under at least my interpretation of the Supreme Court rules and the leading authority on it. But you're right.
My understanding is the primary purpose or reason for the Hughes tolling is to prevent the, if not formal conflict, at least the requirement of conflicting positions that either the plaintiff or the attorney would have to take while continuing to represent, but at the same time arguing whether that representation was adequate or correct, right? So we want to avoid putting these two parties in these conflicting positions. Flesh out for us how that applies in this case. In what way would filing the malpractice suit before the U.S. Supreme Court ruled on the cert petition of a co-party filed by a lawyer that no longer represented your client, in what way would that affect the concern of conflicting positions between the parties?
Well, I certainly agree that was the origin in a simple two-party case, plaintiff versus defendant, one lawyer representing the one party. That was the origin of that tolling rule. But in cases that are more complex, I think you have to have a broader view. You have to look at the interrelationship with the other parties and the ultimate impact that would have resulted from one party's success.
So are you saying that to the extent that the concern over conflicts remains a factor in the analysis, that factor does not weigh in your client's favor here because there was no concern over conflicts?
Well, we wanted Mr. Sandberg to be successful, and so we did not want to file anything anywhere that would have undermined his position that he was taking.
But what you were filing and alleging against Mr. Sandberg, did it create some conflict in the positions that he was continuing to take on behalf of the co-party? Or would the only concern be that it was creating distraction and time commitments and, of having to deal with this lawsuit pending while he was there any conflict in the actual positions of the parties?
There was not conflict in terms of wanting to get the foreclosure sale set aside, but the lawyer was pursuing an affirmative claim on a contingency basis for violation of the automatic stay, and that was a different issue. My client just wanted proper credit to be given in the foreclosure sale, so they had different interests going at it from different directions to get to the same result. So I agree that it's more complex than the original origin of the rule.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Ms. Dallas will present argument for the respondents.
May it please the court. In a multi-party case, as in a single-party case, equitable tolling of a legal malpractice plaintiff's malpractice claim against their attorney under Hughes versus Mahaney and Higgins should end when the legal malpractice plaintiff stops prosecuting or defending their underlying claim. That should be the rule for 3 reasons. First, it is the only application of the rule that is consistent with the enabling language of Hughes, its policy rationales, and this court's prior application of the rule. Second, tying the end of equitable tolling to when the legal malpractice plaintiff stops prosecuting or defending the underlying claim preserves the balance of equity struck in Hughes and apex towing. It is also in line with this court's generally conservative and cautious approach to expanding equitable tolling doctrines while still providing a bright line rule for attorneys and litigants to follow. Finally, it is the only application of the rule that is consistent with the general rule that non-appealing parties are not entitled to appellate relief. What petitioners are asking...
When did Mr. Zive, under your proposed rule, stop prosecuting the appeal? Was it when the mandate issued, when he didn't file a cert petition, or when he didn't file a response as he was permitted to do under U.S. Supreme Court Rule 12.6?
Zive stopped prosecuting or defending the defense of his liability on the guarantee when this court denied his petition for review and he took no further action.
Well, that's what I'm asking about, the "and he took no further action" part. So do we have to wait until the deadline for him to take that further action or not?
When you're sitting at the subsequent legal malpractice action, you're always looking backwards.
Right.
So what you're looking backwards to is when the action stopped. And we can tell that from the docket because nothing else happened after the date, and more than 2 years passed before Mr. Zive filed his
Right,
legal
and I
malpractice
understand it
claim.
doesn't make a difference for this case, but it may for other cases, and so we need to be precise about when the tolling would end. And so I realize you're looking backwards, but would it end at the time of the last action that was actually taken or the last action that could have been taken?
Your Honor, I think to answer that question, we look at how this court created and applied the rule in Hughes. So Hughes says that when legal malpractice occurs during the prosecution or defense of a claim, the statute of limitations on the legal malpractice claim is tolled until all appeals on the underlying claim are exhausted. Now, when the court applied that rule in Hughes, it said that the Hughes's legal malpractice claim was tolled until the Supreme Court denied the motion for rehearing on their application for writ of error. Why? Because the court explained in footnote 6, that was the last action of right that the Hugheses could take and did take on the underlying claim.
But they couldn't have gone to the Supreme Court the U.S. Supreme Court in that case.
That's true, but 10 years later in apex towing, the court applied, under a different set of facts, the court applied its rule the same way. The parties in that appeal, plaintiffs were personal injury plaintiffs who sued defendants. Defendants were the ones who had the legal malpractice claim based on their allegation that the attorney failed to assert a certain defense that would have reduced their liability significantly. And the court, because the parties didn't fully prosecute the appeal or wait for a judgment on appeal, the court determined that tolling ended when the Court of Appeals, pursuant to, I assume, an agreed motion to dismiss based on the settlement, when the Court of Appeals issued its order dismissing the appeal. That was the date that the court decided that was the date that the apex towing court decided that tolling ended, because that's the date that reflects the last action of right that the party could take and did take in defending those claims that were at issue in the underlying litigation in apex towing.
So if we take a step back and we've got 3 possible rules here. We've got any appeal by any party, the tolling continues until the litigation is finally concluded. We've got you have to file your own appeal if you want to benefit from the toll. You have to take the action yourself, whether another party does or not. And then we've got the middle rule that's sort of fact-dependent about, is the judgment intertwined? Would you get relief if the other party gets a reversal? Why would you say the place to draw the line is the rule that you favor, that you have to file your own appeal regardless of what anybody else does, and not either of those other two options?
Your Honor, ending equitable tolling when the legal malpractice plaintiff takes their last action of right in the case or decides that they're going to stop prosecuting or defending that other underlying claim best preserves the balance of equity struck in Hughes, which was designed to, on the one hand, protect litigants, legal malpractice litigants, from having to take inconsistent positions in the underlying claim and the legal malpractice claim, and also recognizing that in a legal malpractice claim, it may be difficult to determine accrual of damages if the underlying claim is still ongoing. And then,
isn't that true here as well? If the underlying claim is still going, it's difficult to determine the damages because we don't know what the deficiency was if the foreclosure sale has been set aside.
Ziv's underlying claim was not ongoing. The litigation was ongoing, but the claims asserted by Affeltuni and Grapevine Diamond in this case for wrongful foreclosure were wholly independent. And
I'm not sure we have the record to determine that at this stage because the guarantee agreement's not in the summary judgment record.
what is in the summary judgment record is the Dallas Court of Appeals opinion in the underlying case, where they explain why the summary judgments that were granted against Affeltuni and Grapevine Diamond, on the one hand, on their third-party claim for wrongful foreclosure, as well as Citibank's summary judgment against Zive on the guarantee, why summary judgment was proper in both of those cases. And there is the language of the guarantee agreement, the operative language of the guarantee agreement, that said that Mr. Zive had no defenses or offsets or rights of offset. It is explained and set out in the Dallas Court of Appeals opinion.
I saw the offset language, but offset is something different. That's a statutory claim that you can bring to say the sale that happened was not for fair market value, and if it had been, then the deficiency would have been much less. That's not really what we have here. What the other co-parties were arguing in the U.S. Supreme Court is that the sale should be nullified entirely, and it seems like that would determine the amount of the deficiency that he owed. That seems different from a statutory offset to me. So that's why I was looking for the language of the guarantee agreement to see what his liability would be in the circumstance where there was no foreclosure sale, and it doesn't appear to be in the record.
Your Honor, I believe Clerk's Record 130 and 131 answers your question. The Dallas Court of Appeals there says, as guarantors have agreed that there are no defenses, counterclaims, or offsets to the payment or performance of any of his obligations in regard to the loan. So,
but again, this is not an offset situation.
Your Honor, you're correct that this is not an offset situation, but the entire guarantee agreement, there's a lengthy discussion by the Dallas Court of Appeals that the guarantee agreement obligated Mr. Zive under the loan. Regardless of whether there was a foreclosure sale, if the maker on the note defaulted, Zive had the same liability as the maker.
But we don't know that from the record.
I believe we do, based on the discussion that the Dallas Court of Appeals engaged in the
I read it. I'll go
case.
read it again. It didn't seem like it addressed that issue to me. But if it didn't, then it seems like we would just reverse the summary judgment and send it. It would go back, and then people could put in evidence about that at the trial court level to be able to decide whether. And if we were to go with the intertwined judgment rule, where it matters whether the relief that they would have gotten in the U.S. Supreme Court would have benefited Mr. Zive or not, and that turns on the language of the guarantee agreement, it just seems like we send it back and then the trial court can take evidence on that and make a decision on it.
Your Honor, I understand your thought there. However, I would say that the summary judgment record, the motion for summary judgment filed by Mr. Sandberg, establishes accrual, that the last action of right taken by Zive in the underlying case. It establishes that the legal malpractice claim was filed more than 2 years after that, And that, and we included a copy of the Dallas Court of Appeals underlying opinion, which established that he was liable under the guarantee for different, contractual reasons than were at issue in the wrongful foreclosure case filed by third-party defendant, third-party plaintiffs, Tooney and Grapevine Diamond.
But that wasn't an issue in the Dallas Court of Appeals case, whether he could be held liable even if there were no foreclosure sale, right?
Well, Your Honor, the liability on the guarantee was decided by the Dallas Court of Appeals.
But not under that factual situation where there would be no foreclosure sale because it had been held void. That's what, I don't have the guarantee agreement to know what his liability would be in that circumstance.
I think you're correct about that, Your Honor, but the other aspect of that I was going to address was that in the summary judgment record, the response to the summary judgment doesn't actually raise this issue of intertwined judgments. This came up later in the course of the appeal, as we pointed out in our brief.
But it's your burden as the summary judgment movement.
Yes, Your Honor, but the only argument that was made in response to the Dallas Court of Appeals opinion being part of the record and setting forth the argument that the last action of right he could take and did take under Hughes was after the court dismissed, or on the date that the court dismissed the petition for review.
But I think the Dallas Court of Appeals ruled against you on the idea that he hadn't preserved that argument.
The Dallas Court of Appeals did rule against us on that issue, and we've raised it again here. And of course, this court can determine whether it was an issue or argument that was or was not preserved.
Just shifting focus for a second. If we adopt a rule that it's the last action that a litigant could take and did take, does the rules application here change when, as Justice Boyd was pointing out, the co-defendant or the co-party, plaintiff or defendant, is jointly represented by counsel for the malpractice plaintiff? In other words, does the nature of the representation here, where there's joint representation of two parties, make the general rule difficult to apply?
At the time that Zive opted out of filing a petition for writ of certiorari or joining or responding to the petition for writ of certiorari filed by Tooney and Grapevine Diamond, there was no joint representation. Mr. Sandberg had withdrawn before that period of time, and the entire appellate process was actually prosecuted by different counsel.
So you would say that obviates any problem with the conflict. The only problem there is that the nature of the malpractice claim, I think, is that the joint representation presented a conflict that wasn't adequately disclosed. And so should that change anything, or should it, because withdrawal happened so much earlier, it shouldn't matter?
Your Honor, I think there may be a scenario where joint representation, a problem with joint representation comes into play. I don't think it does come into play here because, again, there was an earlier withdrawal. And because of the rule in Plastex, which is that a non-appealing party is not generally going to be entitled to relief except when the claims are inextricably intertwined. The examples provided in Mr. Zive's brief have to do with indemnity situations, have to do with consortium claims that are sort of inherently tied together with where liability is going to be inherently connected to one party in the case, and then the contingent claim for indemnity or consortium is going to follow that claim. That is not the scenario, that is simply not the scenario that was presented here, and there was no evidence in the record that it was, in the summary judgment record, that it was. It is our position that the better approach here, ending equitable tolling when the legal malpractice plaintiff takes their last right of action or stops prosecuting or defending the claim, is an easily determinable date, because that date can be ascertained by looking at a court's docket.
Would that date sometimes be a court's ruling, and then but sometimes be a litigant's filing?
Your Honor, as applied in Hughes and Apex, the date was actually the date that the court decided or denied the relief that was requested as part of the last action of right. I think what you're looking for is actually the order, but the way that it's articulated is we're looking to the last action of right that the party could take and did take.
But you're actually looking to when the court ruled in response to the last thing that was requested?
That's correct, because the court's order is going to be the sort of effective end of the matter.
What if the Court of Appeals was the end of the line, but the litigant files motions for extension of time to file petitions for review and just kind of keeps the ball in the air for a while? Does that count? I mean, do you sort of play it out as far as
I think as long as the litigant,
even if it wasn't substantive?
I think as long as the litigant is taking action to preserve their ability to continue to pursue the claim, they are continuing to prosecute or defend the underlying claim. When they stop doing that, or when they allow that time to expire, they're no longer prosecuting or defending the other underlying claim.
So would tolling,
would you look to when so if a motion for extension of time would keep the ball in the air, would you want to look to, in the first instance, to when the deadline to file a petition for review ended, as opposed to when the Court of Appeals ruled? Or do you look to the last motion for extension of time? And these are nitpicky questions, but they're going to matter in some cases, and I don't know quite how to.
Sure, I think when you're sitting at the legal malpractice claim trying to determine if limitations has run, you are going to look back at what was the last order that happened in the case, what was the last thing that the legal malpractice litigant did to prosecute or defend the claim. So is it sometimes going to be an order denying rehearing on a writ of error? Well, probably not anymore because we don't have writ of error. But is it going to be the denial of the petition for review? If that's where things end, then yes. Is it going to be the denial of a third motion for extension of time on a petition for review? Yes, perhaps.
We adopted your rule so that limitations stops tolling once the litigant takes the last step as to their individual claim. Do you concede that there would be circumstances where that would force a litigant to file the malpractice claim at a time when it would create a conflict for the lawyer who continues to represent a co-party? Do you concede that would be one result of your rule?
So if I understand your question, you're asking in a situation where, for example, one defendant has settled the claims, but the same attorney continues to represent other defendants in the litigation?
And say the first defendant thinks that the attorney committed malpractice by recommending they settle or by failing to assert a defense or whatever. And so they want to sue this attorney, and under your rule, they have to go ahead and sue the attorney because they've now settled. Do you concede that in some circumstances that's going to put the attorney in a position where they're in a conflict in terms of continuing to represent their current clients but fighting against the malpractice case of the former client?
I think the policy consideration in Hughes, Your Honor, was that the legal malpractice litigant would be forced into taking inconsistent positions in the underlying claim and the legal malpractice claim, not the attorney. And so in the scenario where the underlying litigant has completely settled the claims and obtained a release or a dismissal, they're not going to be in a position where pursuing their attorney for malpractice while the other litigants are continuing to defend the case, where they're taking an inconsistent position in the underlying case and in the legal malpractice case.
So under your rule, we don't have to worry that the client or former client could be put in a position of having to face conflicting interests. But would the lawyer, are there circumstances in which the lawyers would be put in a position of conflict?
I don't know the answer to your question, Your Honor.
under your rule, is it possible that a legal malpractice plaintiff could end up with a windfall? Because if They decide, if co-party A decides not to pursue any further litigation, co-party B goes on and pursues the litigation further. Co-party A files their legal malpractice claim, and it gets decided before the litigation for the other co-party wins its way up and down through the appellate system over years and back to trial. And is it possible under your rule that the legal malpractice plaintiff could get a judgment, and then later the underlying litigation that's still continuing as to the co-party could come out such that there really weren't any damages if that co-party had pursued their appellate rights?
Your Honor, I'm about out of time, but I am out of time, but I will briefly answer your question. I think the more likely scenario, although there are all sorts of possibilities, I think the more likely scenario is that the party who sits on their rights is going to create a situation where the risks of not enforcing and applying statutes of limitations create problems in the subsequent legal malpractice case because they've decided just to wait until, I'm sorry, I've misunderstood your hypothetical a little bit. You are suggesting that if the party does pursue the litigation.
If you've got two parties and one continues to pursue the underlying litigation, the other one doesn't, and they file their malpractice claim, and assume that they're intertwined claims within the Plastex exception, because there are certain types of claims that we've said fall within that, indemnity and that sort of thing. So if the first party that doesn't pursue any more litigation is successful on their legal malpractice claim and they get a judgment against their former attorney, the other party that decided to continue pursuing the underlying claim eventually, years later, because this case takes longer for whatever reason, ends up getting a reversal and eliminating any liability that party would have had, so that party can't bring a legal malpractice claim because they don't have any damages. Because they ended up prevailing in the underlying case. Doesn't it seem like the legal malpractice plaintiff gets a windfall in that particular case under your rule?
If the claims are interrelated, maybe so, but again, I don't think that this case presents an interrelated claims problem scenario.
But you're advocating that we not choose the interrelated claims rule. You're advocating the bright line of could take and did take, and not the circumstance of, you have to decide if the claims are interrelated and if they would get relief, right?
Yes, Your Honor.
Okay.
Any other questions? Thank you, Ms.
you.
Dallas. Mr. Lippy, you have 5 minutes.
Thank you, Your Honor. To address one of the concerns that was raised in terms of conflicts, in arguing to the U.S. Supreme Court that Afflatuni had been damaged by what had been done below, his counsel had to rely upon the affidavits as to value of the property that was foreclosed upon. The Court of Appeals in the underlying decision had said those affidavits couldn't be considered because you missed the expert designation deadline and because my client's affidavit as an owner had certain defects in it that didn't meet the established standards. So if we file our legal malpractice claim while the petition for cert is pending, we would be arguing that those affidavits were wrong and that we suffered damage because they were wrong. That would have created a conflict while the Supreme Court proceedings were pending.
Well, but it wouldn't have been a conflict for your client because they your client no longer had any interest in proving that the affidavits were right.
Well, it would not have been a conflict with my
Well,
client. But
that's what I was asking your friend on the other side. Would it have created a conflict for the lawyer? And I don't think so, because the lawyer would be adamantly arguing both in support of his current client and in opposition to his former client that the affidavits were right.
Well, but on this point, there was a Court of Appeals decision that said these affidavits are defective for these reasons. And so he would have had to try to argue around that.
Sure, both to represent his current client and to defend against the malpractice case.
Right.
He would have to argue that the Court of Appeals was wrong. So I've just been sitting here while the argument's been going on, trying to think of an example where the lawyer would be put in a position of, I think we agree, I think both sides agree, the client wouldn't, the former client wouldn't have a conflict. They got to argue the lawyer screwed up either way, right?
Right.
But would that, and so I've just been trying to flesh out some hypothetical where it would in fact put the lawyer in a position of conflict, and I haven't been able to come, I'm like your friend on the other side, I don't know the answer to that either. I haven't been able to come up with one.
And I finally come back to the point that was a great rationale for the origin of the rule, but it's now a lot more complex with multi-party litigation and overlapping and interrelated claims. And
the other rationale that we gave in Hughes is that the claim's viability depends on the other case's outcome, and so that's why you should toll, because you don't know if you have a legal malpractice claim with any damages yet until the underlying litigation is finally concluded. And so if that's does that point us toward adopting the intertwined claims rule and exception as a basis for determining when tolling ends?
Absolutely, because I understand the court's concern about what's the language of the guarantee agreement. Would it still apply even if there were no foreclosure sale? But the point is, for Affletini to succeed on his claim, he would have to prove a positive value over and above the amount of the liability on the note in order to have a recovery. Otherwise, you know, the violation of this day had created him no harm. In that situation, I don't care what the guarantee agreement says, that wipes out the liability. And so under any stretch of a guarantee agreement, my client's liability is zero. That's why these claims, these rights are so interrelated. In many, many cases, I've experienced this just in the last week in other cases, you piggyback on what other lawyers do. And what some other lawyer representing another party does may benefit my client, and I take advantage of that. This is a situation where the co-party's pursuit of the appeal to the U.S. Supreme Court would have benefited my client. I agree that there's some question about how you read Rule 12.6, but I do believe that my client could have sent a letter to the U.S. Supreme Court or filed a brief on the merits to say that he was joining in Mr. Affletini's position. He was automatically a party to the U.S. Supreme Court. We greatly appreciate the court's time and attention on a matter that's very important to my client and I think important to the jurisprudence of this state. And if there are no more questions, we would...
Any other questions? Thank you, Mr. Lippy. The case is submitted, and the court will take a brief recess.